All right, I see it's 1 o'clock. A quick test. Please, can everyone give me a thumbs up if you can hear and see my presentation slides before we get started. Great to see that's working. Okay, great. Let's get started. Good afternoon to everyone. I trust everyone is well. Welcome to today's webinar titled Aerial Application, All You Need to Know in Terms of Compliance. While the session is scheduled for 2 hours, it will finish earlier, provided there are no glitches. CropLife SA members registered on the CPD system can thereafter complete the very easy assessment loaded in category 1 of the CPD system. Now, I do apologize if I drop off for a minute or two, given network issues in my area. If that happens, please allow me a few minutes to get back online. With that said, let's hope everything runs smoothly. Fingers crossed. Firstly, let me note that we will cover aerial application today in terms of agricultural crops. And while aerial application is also applicable to suitably registered fertilizers, this webinar will focus on suitably registered crop protection products. In terms of the content, the webinar will start with a brief introduction. The focus will then shift to the regulatory framework, where specific sets of legislation regulating the aerial application of crop protection products in South Africa will be covered. The following section will focus on the South African National Standard 10118, which covers the aerial application of pesticides. Under this section, the requirements for commercial and non-commercial agricultural operations, the registration holder, the distributor and crop advisor, as well as the client and aerial application company, will be comprehensively addressed. Finally, the CropLife SA articles, our position statement, and available checklist pertaining to the aerial application of crop protection products will be highlighted. Without wasting any more time, let's get straight into it. When it comes to planning a crop protection spray program for the season, there are various aspects to consider for achieving optimal results, one of which is the correct application method. Producers have a variety of options available to them, provided, of course, that the crop protection product is registered for the purpose and the application method they envisage using. One of these options, if allowed by label instructions, is aerial application, commonly referred to as crop dusting. In some instances, it may be the only suitable application method if, for example, crop fields are too wet for ground-based spray equipment. Other times, aerial application is the best solution due to the crop growth stage or structure. Again, only if the label instructions include aerial application, and this is something that's going to be punted throughout this webinar. Now, there are several advantages of aerial application, such as the ability to treat larger areas in a short period of time, reduced volume of water that needs to be transported, not risking mechanical damage to the crop or soil compaction, as well as not spreading weeds, seed, or diseases by means of equipment, as may be the case in ground-based applications. Some of the disadvantages, however, include sensitivity to adverse meteorological conditions, availability of safe landing strips along with good quality available water at the landing strip, a higher risk of incompatibility in tank mixtures, and, of course, the danger of obstacles such as trees and power lines close to the target areas. In addition, the cost is not always economically viable when spraying smaller areas of land. One matter of serious concern is damage inflicted to neighboring crops, resulting in civil liability claims, especially with herbicides if aerial application is not done strictly by the book. Whatever the reason for choosing this method, the various compliance parameters involved in the responsible aerial application of crop protection products among all role players need serious consideration, of which will be the story for today's webinar. So with that said, let's get started with the regulatory framework. Now, it's no secret to all of us here today that South Africa has a robust framework governing the aerial application of crop protection products to ensure responsible use in agriculture as pilots in this context, as well as farmers and pest management professionals. In South Africa, 3 sets of regulatory tools govern the aerial application of crop protection products, namely the Fertilizers, Farm Feeds, Agricultural Remedies, and Stock Remedies Act, Act number 36 of 1947, which all of you should be very familiar with. The Civil Aviation Act, Act number 13 of 2009, and the South African National Standard for Aerial Application of Pesticides, SANS 10118, together with the supporting regulations of the 2 acts. Let's take a closer look at the 2 acts and SANS 10118. Okay, according to Act number 36 of 1947, a crop protection product that is intended for aerial application must be registered for such application and must have certain clauses from SANS 10118 printed on the label, as well as specific instructions for aerial application. If this information does not appear on the label, then the product may not be used in aerial application. With that said, it is important to note that when a crop protection product is registered for aerial application, this broad heading appearing on suitably registered crop protection products includes all aircraft such as helicopter, fixed wing, or microlight aircraft, remotely piloted aircraft, or multi-rotor devices such as drones. The Registrar of Act number 36 of 1947 may also impose certain conditions on any registered crop protection product, such as limitations on where a product may be aerially applied geographically. It is therefore critical that farmers, producers, and operators of aircraft study the product label carefully and comply with any restrictions. Let's have a look at 2 practical examples involving a product containing the active ingredient glyphosate and another product containing the active ingredient indoxacarb to put this into context. We can see on both labels that the products are registered for aerial application with the clause, and I quote, according to the instructions of the South African National Standard 10118. While clearly setting out the criteria to be met with specific instructions for aerial application in the directions for use so that the product performs as claimed. At the Food for Mzansi Young Farmers in Durban held in February this year, I was approached by a large-scale farmer who queried where to find the aerial application rate for an insecticide product for a particular crop pest problem. Now, this was somewhat surprising. This was a somewhat surprising question, given the scale of this farmer's operations, and in light of the fact that the label of a pesticide product constitutes a legal document under Act number 36 of 1947, of which must be followed without deviation. CropLife South Africa and our members have embarked and continue to feature on various awareness, training, and information campaigns in this regard to ensure farmers understand the legal status of a crop protection product label. With that said, the formula in this context is simple. When farmers are not sure, refer to the product label. And if there is still difficulty in understanding, then seek assistance from crop advisors when unsure about application rate, use restrictions, resistance management, and so forth. Going back to the question, under directions for use, and let's use this snippet from the label of the product containing indoxacarb. The aerial application rate for the crop pest problem, in this case, the crop is cotton, and pests may include bollworm, leafhopper, and fall armyworm. To be applied is 250 milliliters per hectare, of which will have to be calibrated according to the aircraft specifications to be used. Now, as mentioned, the registrar may impose limitations on the geographical locations where a particular product may be applied aerially. This is an example of a product label containing the active ingredient 2,4-D. While registered for aerial application, we see clearly that in KwaZulu-Natal, this product must not be applied aerially. Right, let's soldier on. The Pest Control Operator Regulations number R98 of 18 February 2011, included under Act number 36 of 1947, specifies that a pilot of any aircraft, be it a helicopter, fixed wing or microlight aircraft, remotely piloted aircraft, or multi-rotor devices such as drones used for aerial application, who does so in the course of business, must be registered as an aerial application pest control operator, meaning the pilot must have a registration certificate with a P number and the field of operations specified as aerial application to offer such services, subject to the requirements of the Civil Aviation Act and its regulations, which I will cover going forward. There is often confusion about this aspect of Act number 36 of 1947, as prospective operators think that a specific company can issue these registrations or that a certain course is sufficient for registration, but this is not the case. There are companies that offer courses that will be required as part of the application to become a registered aerial application pest control operator, but the registration can only be approved by the Registrar of Act number 36 of 1947, no one else. Now, to summarize the requirements for aerial application of crop protection products in terms of Act number 36 of 1947. If aerial application of suitably registered crop protection products is executed by a pilot that does it in the course of business, the pilot must comply with Section 72A II of the Act, which states, no person shall for reward or in the course of any industry, trade, or business use an agricultural remedy unless he is a pest control operator registered in terms of this Act or otherwise than in the presence and under the supervision of a pest control operator so registered. So in simple terms, this means that a pilot offering aerial application of crop protection products by any aircraft, which includes helicopter, fixed wing or microlight aircraft, remotely piloted aircraft, or multi-rotor devices such as drones, for commercial gain must conform to the following requirements. Be registered as a pest control operator under Act number 36 of 1947, meaning the pilot must have a registration certificate with the P number where the field of operation is specified as aerial application, issued by the Registrar of Act number 36 of 1947. But remember, registration as a pest control operator is subject to the pilot of an aircraft undergoing training as an aerial applicator, qualifying according to certain standards, which include being a South African resident, 18 years or older, in possession of a relevant and valid SACA qualification certificate obtained from a relevant accredited service provider or degree diploma, as specified in the Pest Control Operator Regulations of 18 February 2011, and not forgetting completing an internship for at least 6 months under the supervision of a pest control operator that is registered for aerial application of crop protection products before being eligible to submit an application for such registration. Now, what about non-commercial applications? For example, a farmer or his or her direct employee conducting aerial application in direct farm operations only does not have to be registered as a pest control operator by the Registrar of Act number 36 of 1947, but is still expected to have a private pilot license in relation to the aircraft model being operated with an agricultural rating and act in accordance with SANS 10118. With that said, and before we get into responsibilities covered in SANS 10118, applicable to all parties involved, let's quickly look at the requirements covered under the Civil Aviation Act, Act number 13 of 2009. The requirements of the Civil Aviation Act, the Civil Aviation Regulations of 2011, and the 8th Amendment to the Regulations of 2015, specifically regulating aircrafts and pilots operating aircraft for aerial application of crop protection products, are as follows. Any aircraft, whether a helicopter, fixed wing, or microlight aircraft, or remotely piloted aircraft and multi-rotor devices used in either commercial or non-commercial operations, must be licensed and certified for aerial application of crop protection products. Now, prior to registering as an aerial application pest control operator, the pilot of any aircraft, which includes those operating remotely piloted aircraft or multi-rotor devices such as drones in this context, will need to be licensed as a commercial pilot in relation to the aircraft model being operated that is issued in terms of the Air Services Licensing Act, Act number 15 of 1990, or the International Air Services Act, Act number 60 of 1993, and have an agricultural rating for aerial application. In addition, the pilot must be in possession of the necessary radio telecommunication equipment, which simply put is a two-way radio system in this context, as well as have the competency, in other words, be certified as proficient in the use of aeronautical radio telephony to operate it. Again, to reiterate, these requirements also apply to drone operators who wish to offer services as aerial applicators. As you will know, there has been a lot of hype around drones and their application in crop spraying in recent times, where strict regulatory requirements such as having to obtain a commercial remote pilot license for the drone operated and an agricultural rating are being punted as a limiting factor to increased utilization of drone technology in agriculture, particularly crop spraying. But is this a fair argument? Despite the punted advantages offered by drones in crop spraying, drone flights have increased public concerns regarding safety and privacy issues. It should be understood that drones are relatively new airspace objects that pose a potential risk to other users of the airspace and to business as well as individuals on the ground, because they mostly operate in the civilian zone of airspace. Airspace traffic control is of vital importance to avoid potentially disastrous collisions between drones and other aircrafts. When taking a closer look at the regulations, all the aforementioned points are accounted for to ensure that whoever operates a drone in South Africa does so legally and responsibly to minimize risk for safety and privacy. Furthermore, when one compares drone regulations adopted in other countries, the similarities for operation become clear. Therefore, the current South African regulation should not be viewed as hindering the uptake of drone technology within this context in agriculture, but rather safeguarding the technology. CropLife South Africa encourages drone operators who wish to offer services as aerial applicators to undergo the necessary training, registration, and licensing in terms of both acts before commencing with aerial application of crop protection products. There is no doubt that drones will be a useful tool in agriculture. However, CropLife South Africa will only recognize drones as a legal aerial application method where drones and pilots meet all legislative requirements and crop protection products applied by drones are registered for aerial application. Finally, before moving on, producers must therefore insist on checking the licensing of a pilot along with his or her aerial applicator's registration under Act number 36 of 1947, as well as ensure that the aircraft is licensed and certified for crop spraying by the Civil Aviation Authority. Now, as alluded to earlier, SANS 10118 for the aerial application of pesticides has definitive instructions on aerial spraying and outlines the responsibilities of all the different parties involved, which includes the requirements for commercial and non-commercial agricultural operations, product registration holder, distributor and advisor, the client, the protection requirements for personnel involved in mixing, loading, and application as applicable to the farmer producer and aerial application company, and finally, the aerial application company itself. The latest 2023 edition of SANS 10118 can be purchased online via www.sabs.co.za. And I encourage everyone involved in the aerial application of crop protection products to have a copy. Right, let's start with commercial and non-commercial agricultural operations. Having covered the requirements for pilots of any aircraft involved in commercial and non-commercial operations, I'm now going to expand on pertinent points pertaining to the aircraft itself. To reiterate, all aircraft used for the for use for the aerial application of crop protection products have to be approved, meaning licensed and certified by the Civil Aviation Authority. With regard to design and installation, the following require special attention in an aircraft with agricultural dispensing equipment. Hopper and spray tank doors need to be carefully sealed, and depending on the type of installation and type of aircraft, isolation of the hopper or tank from the cockpit or cabin by means of suitably sealed baffling may be required. Spray tanks will have to be vented to the outside of the surrounding structure in a manner that prevents the possibility of air currents causing noxious fumes to reach the pilot. A modified aircraft has to be monitored in order to ensure that it is adequately ventilated. Ventilation of the fuselage using blast tubes or openings in the tail of the fuselage may be required. The precautions normally taken in the presence of a combustible mixture will need to be observed. Such precautions include electrically bonding all metal parts, earthing electrical equipment, ensuring that electrical equipment subject to arcing is not installed in the danger zone, proper routing of exhaust manifolds, the safe positioning of discharge and vent openings, and of course, the prohibition of smoking. Finally, the aircraft in service must be regularly inspected in accordance with maintenance schedules as approved by the Civil Aviation Authority, and any suspected leaks or other faults in the dispensing equipment must be recorded and be repaired immediately. Reinspection and confirmation of proper repair will need to be recorded and signed by the designated inspector, which in South Africa means the Civil Aviation Authority. This is very important. Now, the registration holder, as noted earlier, must ensure the label of a crop protection product that may be applied aerially complies with the requirements of Act Number 36 of 1947, and that the accompanying safety data sheet for the product can be sourced either by searching the manufacturer's website or referring to the Agri-Intel database. Now, importantly, the registration holder is responsible for the technical quality of their formulated product. What this means is that the registration holder can be held accountable for poor performance or crop damage resulting from application if the product was strictly applied according to the criteria set out under aerial application and directions for use on the label, and where certified chemical analysis undertaken by the farmer producer substantiates this allegation. Now, why must the farmer provide the proof? Well, remember, according to South African law, it is the individual making the claim of product failure in this context that has to provide verification proving that the product is not of the chemical and physical properties as claimed on the registration thereof. Conversely, the registration holder cannot be held accountable for the failure of a product, crop damage, human impact, or environmental impact caused by the product if it was not applied strictly according to label instructions. This is because the registration holder has no control over the application of their product unless it is done by one of their own staff, which is highly unlikely. Now, CropLife SA affiliated distributors and crop advisors are well aware of regulation number R1716 of 26 July 1991 of Act number 36 of 1947, which prohibits the purchase, sales, use of which includes handling, mixing, and applying, as well as the disposal of any registered crop protection product contrary to label instructions by any individual. Now, when it comes to requirements pertaining to crop protection products recommended for aerial application by technical teams within distribution companies and affiliated crop advisors, the following information must be recorded in writing for the client, in this case, the farmer producer, who will then hand over the written instructions to the pilot who is to conduct the aerial application operation for logging purposes. This, I think, is quite straightforward and will prove most valuable to serve as evidence in the event of disputes with clients. The following will need to be recorded: the client's name and address, their phone number and the name of the farm, identification of the land to be treated, preferably by means of a map or GPS coordinates, the exact size of the land in hectares, instructions provided in accordance with the label, details of the pests to be treated, for example, insects, fungi, and weeds, the stage at which land needs to be treated, of which generally depends on the growth stage of the crop or pest, and time limits according to the label directed instructions. For example, aerial application of suitably registered glyphosate-pesticide products must not go beyond the 8-leaf stage for glyphosate-tolerant maize, because application after this stage could result in delayed maturity and or yield loss. With that said, directed applications may be made after the 8-leaf stage if row spacing permits the movement of the sprayer without causing mechanical damage to the crop. On the name and registration number of the crop protection product to be used. If the mixing of more than one product is instructed that are compatible labels with each other, and that the physical properties of the mixture will not damage the crop at any stage of development or damage follow-up crops. The volume of carrier in liters per hectare, mixing instructions including mixing sequence done again according to label instructions, the warnings such as required signage and limitations, for example, weeds not controlled, instar unaffected, drought, or soil variation. Health and safety, as well as general warnings and precautions in respect of the handling, mixing, and applying of the recommended crop protection product, the required PPE for the products and re-entry periods after application as stated on the label, and finally, procedures required in case of a spill or exposure to humans, the environment, or non-target organisms, with reference to the accompanying safety data sheet for products. Now, the distributor or crop advisor cannot be held accountable for the failure of a product, crop damage, human impact, or environmental impact caused by the product if it was not applied strictly according to label instructions and advice that was offered in full compliance with label instructions. This is since the distributor or crop advisor has no control over the application of the product supplied unless it is done by one of their own staff, which is unlikely to happen unless those staff members are registered pest control operators. However, the distributor or crop advisor can be held co-accountable together with the farmer, producer, and pilot who applied the product for the failure of such product, crop damage, human impact, or environmental impact caused by the product, only if the distributor or crop advisor issued written instructions or offered verbal advice that contradicts the label instructions. Remember that any action, whether written, verbal, or inferred, to draw attention to the use of a crop, to draw attention to the use of a crop protection product is regarded as advertising, and advertising is regarded as selling in terms of Act number 36 of 1947. So any advice, whether advertising sensu stricto, must therefore be only according to label instructions. Now, very quickly, why do I use the term co-accountable and not accountable in this context? Simple, because it is still the client and pilot's responsibility to read and adhere to the label instructions in terms of Act number 36 of 1947. In a case of product failure, where the product was used strictly according to label instructions and where the target crop pest has the ability to develop resistance to crop protection products, such an incident must be reported by the distributor or crop advisor to the relevant Resistance Action Committee and the registration holder for further investigation. Crop protection product resistance is generally a consequence of continuously utilizing the same product or similar products with the same mode of action group without rotation with suitably registered products from different mode of action groups, or using lower or higher dosage rates than those indicated on labels of crop protection products. Farmers need to understand that when resistance of a pest to a pesticide is confirmed, this puts unnecessary pressure on researchers to identify other chemical formulations. This is a timely and costly affair which farmers cannot afford. Farmers should do their best to manage resistance by understanding the contributing factors. Firstly, implement the principles of integrated pest management, better known as IPM, in pest management programs. It is important that farmers do not spray until the pest species has reached the economic threshold level, which is the level at which the pest infestation becomes harmful to crops as determined for a particular farm through consultation with pest management consultants or advisors. Spraying automatically based on sightings is an unnecessary expense that can do more harm than good and drive a pest species population to resistance. Secondly, the correct rotation of crop protection products registered for pests highly susceptible to developing resistance is crucial. It is important to adhere to label instructions pertaining to resistance management guidelines of crop protection products for pests that are prone to developing resistance. For example, if the label of a product instructs that the product be applied twice in a block and then must be rotated with the suitably registered different mode of action group product for subsequent sprays, this must be adhered to. Thirdly, always follow label instructed mixing guidelines when it comes to application rate in particular. A stronger mixture will have no effect on a species carrying a resistant gene. Do not be carried away by those who advocate mixing different crop protection products together to inhibit resistance that is contrary to label instruction. Such action is dodgy practice and may result in more issues such as damage to crops. When it comes to resistance management, it is always important to stay abreast with the latest information through the resistance action committees established by CropLife South Africa that bring together experts to share insights and make informed decisions on addressing resistance. While there have been many reports pertaining to suspected resistance of susceptible pest species, the lack of efficacy of crop protection products reported were largely due to incorrect application and not adhering to label instruction, faulty spray equipment, and incorrect calibration. Finally, to reiterate here, reading labels, seeking expert advice when unsure, and adhering to stewardship principles are crucial when it comes to managing crop protection product resistance. Now, in the case of a target pest which does not have resistance issues, and where the product was used strictly according to label instructions, then as I covered under the registration holder, the farmer producer making this claim will have to substantiate the claim with the chemical analysis, proving that the product is not of the chemical and physical properties as claimed on the registration thereof, which must be submitted by the farmer producer to the registration holder of the product and not the distributor or crop advisor. Why? Because a distributor or crop advisor has no control over what is filled into containers or packed into the packaging. Right, let's move on to the client now. In general, requirements for the client, in this case a farmer or producer, involves being aware of the precautions, resistance management, instructions, use restrictions, directions for use, health risks, and of the advantages and limitations of the recommended crop protection product as set out in the approved label of the product. The final decision on which crop protection product, aerial application company, aircraft, and pilot to be used rests with the client. The client must also decide whether or not the application will be conducted, for example, in case of imminent rain, high winds, or high temperatures. Further, the client needs to be well informed of nearby surrounding communities or sensitive areas within 5 kilometers of the field to be sprayed and must ensure that the pilot is informed accordingly. Now, when it comes to warnings, farmers producers must take note of the following. The public and neighbors in the immediate vicinity adjacent to the spray zone will need to be informed about the aerial spray operation in the area by notices posted at relevant sites and only in the case of emergency applications via social media. The warnings on the registration holder's label, as approved by the Registrar of Act Number 36 of 1947, must be adhered to. The farmer producer has to develop an awareness strategy to involve the community and other stakeholders in all stages of the aerial spray program, as well as inform these persons of any impending aerial application operation where the following must be included: a description of the hazard class of the crop protection product, the envisaged period of aerial application and the specific re-entry period, the location of the area to be treated, the name and contact details, which includes a contactable phone number of the pilot and aerial application company, as applicable, involved in conducting the aerial spraying operation, as well as the contact details, which again includes the contactable phone number for the Office of the Registrar of Act Number 36 of 1947. In terms of landing sites, while there are farmers, producers who expect this service from the aerial application company and pilot appointed to conduct the operation, meaning that mixing and loading is done on their business premises, there are also many farmers which have landing sites on their farms for this purpose. For anyone not familiar with landing sites, I will quickly run through the criteria. Landing sites must be located as close as is practicable to the area it is to serve. When a landing site is to serve more than one area, it needs to be located centrally. Landing sites will need to be accessible to ground vehicles, large enough to allow for safe landing and takeoff under conditions of maximum load, and far enough away from obstructions such as light poles to render the sites entirely safe. Where practicable, the area around the landing site should be fenced off to protect both the aircraft and any stacked crop protection products against interference by unauthorized persons or by stray animals. With that said, remember, it is also the farmer's producer's responsibility to supply water at the landing site, which can be achieved through the installation of a tank at the site using a water trailer to cart water, or having the strip erected close to a borehole or dam. Now, before we move on, where a farmer producer does not have a suitable landing site, but the neighboring farm has a suitable landing site, permission to utilize the site must firstly be sought from the neighboring farmer. With that said, always remember that pilots have the final say as to whether a strip is safe to use or not. It is therefore imperative for the farmer producer to contact the aerial applicator to discuss landing site requirements well in advance. With regard to the effectiveness of the aerial application treatment, the farmer producer needs to ensure that aerial application is undertaken at the correct stage of crop pest development, or whichever is applicable, and according to the criteria set and directions for use on the label of the crop protection product, in order to ensure that the desired results are realized. Where written instructions are obtained from distributors or their affiliated crop advisors, farmers producers must be clear that all instructions provided do not contradict the product label. Remember, as I said earlier, the farmer producer and aerial applicator are still required to read and follow label instructions in terms of the regulations under Act Number 36 of 1947, which I covered during the start of this webinar. Now, buffer zones are defined as areas where spraying does not take place between the downward edge of the application site and an identified sensitive area. Buffer zones have to be established by and between the farmer producer and pilot at the time of application by conducting a local risk assessment with regard to associated hazards, exposure, or overall risk, or both. Any product label precautions, buffer zones must be complied with as highlighted on the 2,4D herbicide label example on your screens, and take note that when wind speeds exceed 15 kilometers per hour, spraying is prohibited to ensure the spray mixture does not drift to and cause significant damage to sensitive areas. In general, a buffer zone must be present between the application area and human settlements, natural areas, water bodies, susceptible crops and ornamentals, and not forgetting farm animals. Finally, the farmer, producer, or the representative must be present to observe the quality of and conditions during the aerial application and to sign the pilot spray logbook after application to confirm the accuracy of the pilot's information in relation to the conditions that existed during the spray operation. This is important to disprove any civil liability claims brought against the farmer producer who commissioned the operation in line with the applicable legislation and label instructions. Where the person making the claim of damage, and in most instances this will be neighboring farmers with susceptible crops or residential estate owners, provides evidence of their own. Now, before we move on to the aerial application company, let me touch on a few additional responsibilities where some are reiterated given their importance. These involve the farmer producer must ensure the written instructions obtained from the distributor or crop advisor are conveyed to the pilot who is to apply the registered crop protection product. The farmer producer needs to ensure the pilot is aware of the exact size of the land to be treated and susceptible neighboring crops, where the farmer is strongly advised to request a signed declaration of this prior to the application. Farmers producers must remind pilots, whether employed by an aerial application company or where the aircraft is rented, that pumps must be switched off when flying over areas not scheduled for treatment and in particular sensitive areas. The farmer producer must ensure water to be used for mixing the crop protection product is analyzed periodically to ensure that sufficient water of acceptable hardness and known pH is utilized. The crop protection product needs to be delivered to the mixing and loading operation area in time. Markers must be inanimate. For example, colored flags, which means no human markers are to be used, where inanimate markers must be positioned permanently in cases where aerial applications are undertaken on a regular basis. Authorized farm employees who place the markers must be in full correct personal protective equipment, of which I will discuss in more detail next. And these workers must move upwind and away from the markers during the application of any crop protection product, while also avoiding walking through a freshly treated area. Farm animals and unauthorized persons are to be kept away from areas where crop protection products are stacked and from the relevant areas during mixing, loading, and application until the landing place has been cleaned up after application operations. All field labor and their belongings, for example, lunch boxes, clothing, and water containers, need to be removed from the spray area to a sufficient distance so as not to be affected by the spray operation. All pedestrian traffic through the area will need to be halted. All employees on the farm need to inform their relatives and people living with them not to enter the sprayed land where the re-entry period stipulated on the approved label of the crop protection product is adhered to. I'm just going to take a quick sip of water, everyone, before I continue. Okay, let's continue. Under no circumstances must harvesting or grazing be permitted immediately and within the withholding period after the application. In the event of a spillage, the farmer producer must refer to Section 6, accidental release measures of the relevant safety data sheet for the crop protection product involved. The Griffin Poison Information Center may also be consulted for this purpose when unsure on 082-446-8946, and this is also the number printed on many crop protection product labels to be called for expert advice in the event of a major spillage, for example, where a plane carrying 2 tons of chemical crashes. Such an incident must also be timeously reported to the Directorate, Hazardous Waste Management and Licensing of the Department of Forestry, Fisheries and the Environment, better known as DEFI. Finally, farmers producers must guard against allowing unclean, hazardous, empty product containers to build up on farms. According to the National Environmental Management Waste Act, Act number 59 of 2008, farmers are not allowed to burn, bury, reuse, sell, or donate empty crop protection product containers. The only option available is recycling. These containers must be cleaned by a method that renders the containers nominally empty, meaning non-hazardous. This involves triple rinsing to remove residues and puncturing to render the container useless. Farmers are encouraged to refer to the CropLife SA cleaning guidelines available to farmers on our container management webpage, accessed through our website, www.croplife.co.za. Once containers have been triple rinsed and punctured, according to the CropLife SA procedure, farmers must then access our list of certified recyclers arranged according to province on our website and make contact with the certified recycler in the area to arrange for disposal of the triple rinsed punctured empty containers at the recycler's site. As mentioned, empty containers cleaned according to our triple rinsing guideline are not deemed hazardous and may be transported by farmers for disposal at the site of a CropLife SA certified recycler without any further legal liability. Farmers must insist on being issued with a certificate proving adequate and lawful disposal from the certified recycler. Note that empty containers which have not been adequately cleaned will not be accepted by our recyclers because such containers are considered notionally empty, meaning hazardous. Farmers should keep all certificates of disposal safely filed to prove compliance, which may be required by state inspectors, auditors, or certification agencies, such as Global Gap for access to international markets. Finally, note that while I have focused on empty containers here, there are various forms of crop protection product packaging to consider. But not to worry, we have scientifically proven cleaning guidelines for all types of crop protection product packaging available on our website that have been developed by the industry's very own Dr. Gerard Verduren. Right, let's move on. When it comes to protection, the Hazardous Chemical Agents Regulations of 29 March 2021, covered under the Occupational Health and Safety Act, Act number 85 of 1993, as well as crop protection product labels, compel the use of personal protective equipment, as I mentioned earlier, commonly referred to as PPE. Therefore, all employers must issue employees with appropriate PPE, given that it is law, and we also advise all employers where work involves handling and using crop protection products to have a clause in their contracts which clearly states that employees must wear PPE correctly while working with crop protection products, where the level of PPE is determined by the nature of the products that will be applied through the precautionary statements based on the new format, GHS labels, and safety data sheets. Employers are strongly advised to maintain a signed register on PPE issued to each employee in this regard, which will serve as evidence in the event of any disputes. I should also clearly state that PPE is personal, and therefore the responsibility of the person who is issued with it to wear it and take care of it. Employees involved in the handling, mixing, and loading of pesticides must understand that they are subject to intense exposure and have a right to be provided with appropriate PPE by their employer, which is further specified in the South African National Standard 10206, the handling, storage, and disposal of pesticides, as well as SANS 10220, the selection, use, and maintenance of respiratory protective equipment. Now, in short, the minimum requirements include full body cover, generally long sleeve cotton shirts, pants and plastic apron, head cover, which generally involves the use of a wide brim cotton hat, foot cover in the form of rubber boots, hand cover with rubber gloves, eye protection with the use of safety goggles, and nose and mouth protection, which would involve either a dust mask or respirator, depending on the toxicity of the products and mixture. In general, when working with very toxic crop protection products and mixtures, a respirator will be required. To reiterate, read the product label for any special instructions pertaining to personal protection. Further to this, and during any operation involving a crop protection product, there is to be no smoking, eating, or drinking in the operating area. Soap, clean towels, and clean water are also required to be made available near the operating area. Now also note that the pest control operator, in this context the pilot, and all personnel assisting with mixing and loading will have to undergo health screening annually by a healthcare practitioner registered with the Health Professions Council of South Africa. Farmers, producers, and aerial application companies must also ensure that all authorized employees involved in handling, mixing, and loading, as well as the application of crop protection products during aerial application operations, receive training and any other information regarding PPE. For example, the correct sequence of putting on PPE, removing and cleaning, maintaining, replacing PPE, as well as understanding the risks of not using PPE correctly in their local language. All records in this regard must be safely filed to validate any argument in the event of an incident or dispute with such an employee. Now, this is important. Where the services of an aerial application company are utilized, the company will ensure that all employees for mixing and loading purposes, including the pest control operator, in this case the pilot, who conducts the aerial application, are in possession of the necessary PPE, where the safety of staff during mixing and loading will be monitored by the company's appointed pilot for the operation. To emphasize, the safety, health screening, and precautions of any direct farm employees or personnel authorized by the farmer producer to provide operational assistance during aerial application operations remains the responsibility of the farmer producer. More often than not, farmers producers with landing sites will be required to provide their own staff for mixing and loading operations, where the pest control operator, in this case the pilot, is not a direct employee of an aerial application company, but has rented the aircraft and necessary equipment, where mixing and loading equipment will depend on the agreement with the farmer producer to conduct the aerial application operation. For pest control operators, and again here we are talking about pilots who offer their own services and are not employed by any aerial application company, their safety, health screening, and precautions remain their own responsibility. But where the pilot and his or her support staff are employed by an aerial application company, then their health screening and precautions will be the responsibility of the company. Finally, before moving on, and as a reminder to all employers who have employees handling hazardous chemical agents, in this case, crop protection products with the GHS label, employers must ensure that those employees receive training in order to read and comprehend the new GHS format labels, and in particular, they must know the 4 key elements to look for, which includes the GHS hazard pictogram, signal word, hazard statement, and precautionary statements, of which there are 4 types applicable to prevention, response, storage, and disposal. I'm just going to take a quick sip of water before I continue. Right, let's move on to the aerial application company. Here we will discuss the requirements pertaining to the quality of application, inspection of area to be treated, swath guidance, calibration of the aircraft for application rate, mixing and loading, spray distribution, atmospheric stability, drift, cleaning of equipment, and finally, disposal of empty containers. Let's start with quality of application. The aerial application company will be responsible for evenness, correctness, and quality of application. In addition, the company must strictly adhere to all label instructions and warnings stated on the approved label of crop protection products. The pilot must ensure that application is done in accordance with Act number 36 of 1947 and that the products are compatible and correctly mixed when this is applicable. The aerial application company will carry out the spraying operation upon request by the farmer producer. And remember, as I covered earlier, the final decision on the product, company, aircraft, and pilot rests with the client. Now, before starting any operation, the pilot needs to inspect from the ground or from the air the area to be treated. And in doing so, will locate and note any possible obstruction, for example, residential development, transmission lines, masts or steep inclines, susceptible crops, fields being harvested, or beehives, potential environmental obstacles, for example, watercourses, and request from the farmer producer the confirmation about the source of any such sensitive areas within 5 kilometers from the area to be treated. It is recommended that the pilot uses a system mounted on the aircraft to indicate treatment of flight path intervals or SWAT guidance. If any problem prevents this and where flight paths cannot be logged by GPS, the pilot needs to then utilize non-human markers such as colored flags or tires and inform the farmer producer of their SWAT guidance requirements. Under no circumstances can aerial application be carried out without the use of SWAT guidance. The aerial application company and the employed pilots or a pilot that uses the aircraft, if rented out, will be responsible for the calibration of the aircraft. Aircrafts will need to be calibrated at least once every year and when any changes have been made to the dispensing system. For more information on the formula for the calculation of the dispersing rate, please refer to section 12.4 of SANS 10118. To remind everyone, where the services of an aerial application company are utilized, the company will ensure that all employees for mixing and loading purposes, including the pilot who conducts the aerial application, are in possession of the necessary PPE, where the safety of staff during mixing and loading will be monitored by the company's appointed pilot for the operation, where no smoking, drinking, or eating during the operation is to be tolerated. Equipment to be provided for mixing and loading will be the responsibility of the aerial application company, unless there is an alternative agreement with the client where the company's pilot must ensure that, when applicable, landing strips on farms can be accessed with the truck carrying the mixing and loading equipment and fuel, particularly after rain. Loading of the aircraft must be conducted under the supervision of the pilot and preferably through mechanical means. In terms of spray distribution, the aircraft's distribution pattern must be analyzed at least once every year and when any change has been made to the dispensing system. The sampling and original calculations need to be maintained in a safe place until at least 6 months after the next calibration has been completed successfully. Preferred methods for determining droplet distribution may be accomplished by means of fluorometry, image drop analysis, and water-sensitive paper cards. I am not going to go into details here since this is beyond the scope of this webinar. However, whoever requires more information here can refer to section 12.7 of SANS 10118. Now, in terms of atmospheric stability and drift, firstly, no crop protection product is to be applied in windy conditions if there is any danger of damage or of contamination due to spray drift. Refer to the approved label of the crop protection product for the maximum wind speed allowed for aerial application of that product. If no maximum wind speed is listed, a maximum wind speed of 15 kilometers per hour will apply. However, if the product is in the form of pellets or granules, higher wind speeds can be tolerated, and my advice here to farmers or producers would be to query this with suppliers before proceeding. Secondly, it is crucial to be aware of temperature inversion under calm conditions when wind velocity is below 5 kilometers per hour, particularly for glyphosate-containing herbicides. Inversion conditions normally prevail in the early morning and occur when cool air on the surface is prevented from moving upwards by a pocket of warm air overlying it. Smoke or fog close to the ground is indicative of such conditions. This will result in a spray mixture remaining suspended in the air while not being deposited onto the target, which can result in serious off-target damages. Any of these factors can cause serious off-target drift and should be avoided at all times. During aerial application of crop protection products, drift onto persons, animals, adjacent lands, public roads, footpaths, water supplies, and crops, particularly onto sensitive crops, when non-selective herbicides are being sprayed or when harvesting is taking place, must be avoided. Spray drift has to be minimized by selecting the correct type of formulation and adjuvant and taking into account droplet size, nozzle location, flying height, wind speed, and direction, air turbulence and thermal currents, humidity, and temperature. Again, all of which must not deviate from product label instructions. All pilots involved in the aerial application of registered crop protection products, whether commercial or non-commercial operations, are required to log the following in a book, of which must be corroborated and signed off by the farmer producer or their representative at the end of each operation, as I mentioned earlier. So let's have a look at what the requirements are here. Firstly, the area to be treated in hectares. The written instructions according to product label, which is usually provided by the farmer producer that was received from their distributor or crop advisor. Volume of carrier applied per hectare, the swath width, nozzle type, nozzle or rotary atomizer blade, angle setting and restrictor size as applicable, the spray pressure, takeoff time for each load, wet and dry bulb thermometer readings to determine relative humidity and ambient temperature at the start of an operation and at the start of each spraying cycle, after refilling, wind speed at the start of the operation and at the start of each spraying cycle after refilling, height of the nozzles above target, any exceptional parameters stated on the label, the name and importantly for commercial operations, the pest control operator registration number of the pilot or registered PCO supervisor in the event of an unregistered intern. And finally, the aircraft number. Now, what all of you will have gathered so far is that what I've covered in terms of meteorological conditions, spray volume, droplet size, flying height, atomizers, and wingtip vortices are clearly set out in the criteria to be met for aerial application and the directions for use on crop protection product labels registered for aerial application, putting into importance the legal status of a crop protection product label. Now, although the farmer producer has to greenlight the operation in terms of Act number 36 of 1947 and the conditions pertaining to registration as an aerial pest control operator, both parties involved in the operation have a duty to conduct application operations in line with the label instructions for a crop protection product that is registered for aerial use to control a crop pest problem. With that said, in the case of aerial application, both the client, in this context, the farmer producer, and the pilot, whether employed by an aerial application company or not, are both accountable for damage to human health, crops, livestock, and the environment if products were applied contrary to their label instructions. To reiterate here, only when a distributor or crop advisor issues written instructions or offers verbal advice that deviates from the label instructions can they be held accountable, with the farmer producer who commissioned as well as the pilot who conducted the operation. The advice is simple and as elaborated on earlier, To avoid issues and disprove any false claims arising through disputes or to prove technical quality issues with the product that may have resulted in product failure, do not deviate in any manner whatsoever from the label instructions of crop protection products registered for aerial use. The only time a crop protection product that is not registered for aerial application may be used for such is when the operation is for experimental purposes under the supervision of a government department conducting research in the field, or in terms of a permit obtained from the Registrar of Act Number 36 of 1947 to import and dispense the crop protection product as necessary for the particular experiment. Note here that a trial protocol will have to be submitted for approval of the conditions on the permit by the registrar. Finally, before we move on from here, let me quickly touch on some other responsibilities worth noting. The aircraft must have a safety harness installed for use by the pilot in accordance with the Civil Aviation Regulations of 2011 of the Civil Aviation Act, Act number 13 of 2009. When it comes to cleaning equipment, it is the pilot's duty to ensure that dispensing equipment is thoroughly cleaned and rinsed directly after completion of the spraying operation to prevent contamination of the new batch of spray mixture. With regard to the cockpit or cabin, the pilot needs to ensure that this area is cleaned at frequent intervals. Under no circumstances whatsoever will the clearing of blocked jets or nozzles be done by oral blowing or sucking. This is a sure way of introducing residues into the body and goes against everything I have covered today in terms of personnel protection. For health precautions purposes, the records of all applications in the logbook need to be kept for a period of 10 years in a safe place to prevent it from being mislaid, stolen, or being tampered with. Again, to reiterate here, for pest control operators, and again, here we are talking about pilots who offer their own services and are not employed by any company. Their safety, health screening, and precautions remain their own responsibility. But where such a pilot is employed by an aerial application company, then his or her safety, health screening, and precautions will be the responsibility of the company. All pilots undertaking commercial aerial application operations involving suitably registered crop protection products must renew their pest control operator registration every third year by submitting an application for renewal in the prescribed manner to the Registrar of Act Number 36 of 1947. Note that proof of a medical examination conducted by an occupational health practitioner registered with the Health Professions Council of South Africa and a copy of all application records from the logbook for the last 6 months before the renewal period will be required. All pilots, regardless of commercial or non-commercial aerial application operations and aircraft, which includes drones, will need to renew their pilot's license annually by forwarding the skills test, the last 3 pages of application records from the logbook, a valid medical certificate, and a 12-month logbook summary before the date of application. All aircraft licensing and certification, and again, this includes drones, will need to be renewed annually, where renewal will be subject to an inspection by the Civil Aviation Authority, regardless of whether the aircraft in question is being used for commercial or non-commercial aerial application operations. Pilots, whether employed by an aerial application company or where the aircraft is rented, must always remember to switch off pumps when flying over areas not scheduled for treatment, and in particular sensitive areas. In order to avoid issues with leftover spraying mixture requiring disposal, pilots must ensure only as much product as will be needed at one time for a specific application is prepared and will be applied strictly in accordance with the instructions on the label. Where loading and mixing operations are conducted on the premises of the aerial application company, the empty product containers must be triple rinsed and punctured according to the CropLife SA triple rinse procedure, and recycled through our network of certified recyclers across the country, as I highlighted when this was covered, when this was addressed earlier in the context of farmers, producers. I encourage anyone who has dialed in to this webinar today who is wanting more information on this subject to please visit our website where all the necessary information and resources in user-friendly formats can be sourced. Right, before I sign off for today, I'm going to highlight what CropLife SA has done to date in terms of our aerial application articles, position statement, and checklist to drive our message of compliance among farmers, producers. Let's start with articles. Now, Ariza Theron, our advocacy and communications manager, has published 2 brilliant articles in the SA Grain magazine, where the one summarizes compliance with the regulations that govern aerial application technologies, and the other takes a look at crucial factors to consider before undertaking an aerial application operation. Now, for me, the great thing about these articles is that I can easily read them both in 10 minutes and have a fair understanding of what is required in terms of compliance with the applicable legislation when it comes to the aerial application of crop protection products in the agricultural crop arena. While the articles were published in 2021 and 2022 respectively, they still remain quite relevant. By searching the CropLife SA website under resources, our position statement on aerial application can be found. It is a simple but comprehensive summary of what I've covered during this webinar and also provides the association's position on the aerial application of herbicides containing the active ingredient glyphosate, which has been the subject of media controversy. CropLife SA is clear that application of any crop protection product which is contradictory or not specified on the label is a contravention of the law and should be handled as such. We are also firm in that when a crop protection product is used strictly according to label for a particular crop pest situation, users can be guaranteed that the product will be effective in controlling the target pest while mitigating any risk to applicators or the environment. Why? Because registration holders have done copious amounts of research and safety studies to validate the instructions printed on product labels. And saving the best for last, the association has made available an aerial application checklist for pesticides that can be downloaded via our website. This checklist is a summary of the existing legislation that control the aerial application of pesticides. It is not a list of requirements compiled by CropLife South Africa, but a guideline checklist to assist farmers in ensuring compliance prior to undertaking any aerial application operation. Farmers are therefore strongly encouraged to utilize the simple yet highly effective guideline checklist to checkbox the 10 compliance items before greenlighting aerial applications. Finally, and to conclude, I would like to leave all of you with this. Practice responsible aerial application of crop protection products, not just because it's a legal obligation, but because it's the right thing to do as proud South African citizens. And with that said, it now brings to a close this webinar session. I trust all of you enjoyed it and also learned something. Thank you all for being part of this webinar session. Let me just quickly check if there are any questions. I see Gerard has been busy answering questions. Okay, so I see Gerard's basically answered. I'm not going to get stuck in there because Gerard's basically an aviation expert himself. So I see a question from Nick. Where can a copy of this webinar be found? Nick, once ready, once our advocacy and communications manager, Riza Theron, has edited this webinar, it will be available on our website under resources via the crop protection tab on our website. So you'd be able to access it there. Yeah, so I don't see any more questions, but for those of you who may want to chat further around this topic going forward, please feel free to contact me via cell or email as per the details appearing on your screens. All the best to everyone that will be doing the assessment, Again, as a reminder, the assessment is loaded in category 1 of the CPD system. If you listened and concentrated during this training session, 100% should be the order of the day. Have a great weekend and be safe. Cheers, everybody.